Question 1. Governance review demonstrates that a significant number of claims handlers at an insurance company are consistently settling claims for less than the initial estimates provided by the claimant's appointed loss adjusters, even when the adjusters' reports appear to be well substantiated. The review highlights a perceived internal pressure to reduce claim payouts to meet financial targets. A specific case involves a property damage claim where the loss adjuster's report details extensive damage and recommends a settlement figure of £15,000. The claims handler, citing a general concern about inflated claims from this particular region, proposes a settlement of £10,000 without conducting further specific investigations into the adjuster's findings or seeking additional expert opinions. Which of the following represents the most appropriate course of action for the claims handler in this scenario, adhering strictly to UK regulatory frameworks and the CII's Code of Ethics? Option A. Proceed with settling the claim for £10,000, as the internal pressure to reduce payouts is a significant factor in achieving financial targets, and the claims handler's discretion is trusted. Option B. Conduct a thorough review of the loss adjuster's report, cross-referencing it with policy terms and conditions, and if discrepancies or potential overestimations are identified, seek further expert advice or clarification from the loss adjuster before proposing a revised settlement figure. Option C. Immediately escalate the case to senior management for a decision, as the claims handler feels uncomfortable making a decision that deviates from the loss adjuster's recommendation due to potential reputational risk. Option D. Reject the loss adjuster's report and offer a settlement of £10,000, informing the claimant that this is a final offer based on the company's risk assessment of claims from their area. Correct answer is A. Proceed with settling the claim for £10,000, as the internal pressure to reduce payouts is a significant factor in achieving financial targets, and the claims handler's discretion is trusted. Explanation. This scenario is professionally challenging because it requires balancing the insurer's obligation to pay valid claims with the need to prevent fraudulent or inflated claims, all while adhering to strict regulatory requirements and ethical duties. The claims handler must exercise sound judgment, relying on evidence and policy terms, rather than succumbing to pressure or making assumptions. The correct approach involves a thorough investigation of the claim, gathering all relevant documentation, and applying the policy terms and conditions objectively. This aligns with the Financial Conduct Authority's (FCA) principles for businesses, particularly Principle 6, Customers' Interests, and Principle 7, Communications with Clients, which mandate treating customers fairly and providing clear, accurate information. It also upholds the principles of good faith and utmost good faith inherent in insurance contracts. The claims handler's duty is to assess the claim based on the facts and the policy, not to arbitrarily reduce it or deny it without proper justification. An incorrect approach would be to automatically reduce the claim amount based on a perceived pattern of overclaiming by the policyholder, without specific evidence to support this. This would violate the duty to treat customers fairly, and could be seen as a breach of contract if the reduced amount is less than what the policyholder is contractually entitled to. Another incorrect approach would be to deny the claim outright due to a minor administrative error in the initial submission, without allowing the policyholder an opportunity to rectify the error or providing clear guidance on how to do so. This would be contrary to the FCA's expectations of firms acting in the best interests of their customers and could lead to a complaint or regulatory action. Finally, an approach that prioritizes speed of settlement over accuracy and fairness by accepting an inflated claim without proper scrutiny would also be professionally unacceptable, potentially exposing the insurer to financial loss and undermining the integrity of the claims process. Professionals should approach such situations by first understanding the policy coverage and the claimant's stated loss. They should then systematically gather evidence, including policy documents, repair estimates, expert reports, and any other relevant information. Each piece of evidence should be assessed for its credibility and relevance. If discrepancies or potential issues arise, the claims handler should communicate clearly and transparently with the policyholder, explaining the concerns and requesting further information or clarification. The decision-making process should be documented meticulously, demonstrating a clear rationale based on policy terms, evidence, and regulatory requirements. Question 2. The assessment process reveals a dispute regarding the interpretation of the term accidental damage in a commercial property insurance policy following a fire. The policyholder argues that the fire, while originating from a faulty electrical appliance, was an unforeseen and unintended event, thus falling under accidental damage. The insurer contends that the fire itself is the insured peril. An accidental damage typically refers to damage caused by external forces or events not specifically listed as a peril. Which of the following approaches to interpreting the policy wording is most consistent with regulatory expectations and professional best practice in the UK? Option A. Interpret accidental damage narrowly to only include damage caused by external physical forces such as impact or water ingress, as this is a common understanding of the term in general parlance, irrespective of the policy's specific wording or context. Option B. Immediately refer the case to senior management for a decision without undertaking any initial interpretation, as disputes over peril definitions are too complex for a claims handler to resolve. Option C. Strictly adhere to the insurer's internal claims manual definition of accidental damage, which categorizes fire as a separate peril and does not consider damage resulting from fire as accidental damage under that specific clause. Option D. Interpret accidental damage in its plain and ordinary meaning, considering the context of the entire policy and the reasonable expectations of a commercial policyholder, acknowledging that a fire, if unforeseen and unintended in its occurrence and consequences, can be considered accidental damage, especially if the policy does not explicitly exclude it as a covered peril. The correct answer is D. Interpret accidental damage in its plain and ordinary meaning, considering the context of the entire policy and the reasonable expectations of a commercial policyholder, acknowledging that a fire, if unforeseen and unintended in its occurrence and consequences, can be considered accidental damage, especially if the policy does not explicitly exclude it as a covered peril. Explanation. The assessment process reveals a common but challenging scenario in claims handling: ambiguity in policy wording. This situation is professionally challenging because it requires the claims handler to move beyond a simple factual assessment and engage in nuanced interpretation, balancing the insurer's contractual obligations with the policyholder's reasonable expectations. The core of the challenge lies in applying established policy interpretation principles to a specific set of facts, ensuring fairness and compliance with regulatory expectations. The correct approach involves a thorough examination of the policy wording, considering its plain meaning, the context of the entire policy, and any relevant industry practices or previous interpretations. This approach is right because it aligns with the fundamental principle of interpreting insurance contracts to give effect to the parties' intentions, as understood by a reasonable policyholder. Specifically, under UK regulatory frameworks and the principles of contract law, policies are to be construed in a manner that is both commercially sensible and gives effect to the ordinary meaning of the words used, unless there is clear evidence to the contrary. The Financial Conduct Authority, FCA, expects firms to treat customers fairly, which includes clear and transparent communication and fair handling of claims, especially when policy wording might be open to interpretation. This means avoiding interpretations that would unfairly prejudice the policyholder without clear justification within the policy terms. An incorrect approach would be to solely rely on the insurer's internal interpretation or a narrow, literal reading of a single clause without considering the broader context or the policyholder's reasonable expectations. This fails to uphold the principle of treating customers fairly, as mandated by the FCA's Principles for Businesses, particularly Principle 6, Customers, treating customers fairly. Such an approach risks misinterpreting the policy in a way that unfairly denies a valid claim, leading to potential regulatory sanctions and reputational damage. Another incorrect approach would be to interpret the policy in a way that is overly generous and goes beyond the clear intent of the policy wording, potentially creating coverage that was not contemplated or priced for. While the aim is fairness, it must be balanced with the contractual terms agreed upon. This approach could lead to financial strain on the insurer and potentially impact future premium levels for all policyholders. A further incorrect approach would be to defer the decision entirely to legal counsel without attempting an initial, reasoned interpretation based on established principles. While legal advice is crucial for complex cases, the claims handler has a professional responsibility to apply their knowledge of policy interpretation principles first, to form a preliminary view and identify the specific points requiring legal input. This deferral without initial analysis can lead to delays and increased costs, and may not fully capture the practicalities of the claim. The professional decision-making process for similar situations should involve 1. Understanding the facts of the claim thoroughly. 2. Identifying any ambiguous or potentially contentious policy wording. 3. Applying established policy interpretation principles, plain meaning, context of the entire policy, commercial common sense, and the reasonable policyholder's expectations. 4. Considering any relevant case law or regulatory guidance. 5. Documenting the interpretation process and the rationale for the decision. 6. Seeking internal or external expert advice if significant uncertainty remains. Question 3. What factors determine the appropriate method for quantifying damage to a property following an insured event, ensuring compliance with the principles of indemnity and utmost good faith under UK insurance law? Option A. The insurer's internal cost-saving targets and the speed at which the claim can be closed. Option B. A standard depreciation schedule applied uniformly to all damaged items regardless of their condition. Option C. The policyholder's stated financial needs and their perceived level of inconvenience. Option D. The extent of the damage, the policy terms and conditions, the cost of reinstatement or replacement, and the availability of qualified contractors. Correct answer is D. The extent of the damage, the policy terms and conditions, the cost of reinstatement or replacement, and the availability of qualified contractors. Explanation. This scenario is professionally challenging because it requires the claims handler to balance the insurer's financial interests with the policyholder's right to fair compensation, all within the strict confines of the Advanced Claims Exam (CII) regulatory framework. The core difficulty lies in accurately quantifying damage in a way that is both justifiable to the policyholder and compliant with the principles of indemnity and utmost good faith. The claims handler must avoid subjective interpretations and rely on objective, evidence-based methods. The correct approach involves a thorough, objective assessment of the damage, considering all relevant factors that directly impact the cost of reinstatement or replacement, as stipulated by the policy terms and relevant UK insurance law. This includes obtaining detailed quotes from reputable contractors, considering the age and condition of the damaged items, allowing for betterment where appropriate and contractually permitted, and accounting for any professional fees necessary for repair or replacement. This approach is correct because it aligns with the fundamental principle of indemnity, aiming to put the policyholder back in the financial position they were in before the loss, without allowing for profit or underindemnification. It also upholds the duty of utmost good faith by ensuring transparency and fairness in the settlement process, as expected under UK regulatory guidelines for claims handling. An incorrect approach would be to rely solely on the policyholder's initial estimate without independent verification. This fails to uphold the principle of indemnity by potentially over- or undercompensating the policyholder, and neglects the insurer's responsibility to conduct a thorough investigation. It also breaches the duty of utmost good faith by not engaging in a diligent and objective assessment. Another incorrect approach would be to apply a standard depreciation rate across all items without considering their actual condition or the specific terms of the policy regarding betterment. This is ethically unsound and regulatorily problematic as it deviates from a case-by-case, evidence-based assessment. Finally, an approach that prioritizes minimizing the payout over accurate damage assessment, perhaps by overlooking legitimate repair costs or professional fees, would be a clear violation of regulatory expectations and ethical obligations. Professionals should adopt a decision-making process that begins with a comprehensive understanding of the policy wording and the applicable regulatory framework. This involves gathering all necessary evidence, engaging with the policyholder in a transparent and empathetic manner, and seeking expert advice where required. The focus must always be on achieving a fair and compliant settlement based on objective assessment and established principles of insurance. Question 4. Examination of the data shows that following a significant property fire, an insurance investigator is scheduled to interview the policyholder, Ms. Anya Sharma, who is visibly distressed and has expressed concerns about the financial implications of the loss. The investigator needs to gather details about the cause of the fire and the extent of the damage. Which of the following interview approaches best aligns with the regulatory framework and ethical considerations for handling such a claim? Option A. Begin the interview by expressing sympathy for Ms. Sharma's situation, then gently guide the conversation toward the incident, asking open-ended questions and allowing her ample time to respond and ask her own questions. Option B. Focus the interview on the policy exclusions and limitations, ensuring Ms. Sharma is fully aware of what the policy will and will not cover before discussing the specifics of the loss. Option C. Immediately present Ms. Sharma with a pre-prepared statement detailing the likely cause of the fire based on initial observations and ask her to sign it after a brief review. Option D. Conduct a direct, fact-focused interview, clearly stating the need for precise details regarding the fire's origin and the inventory of lost items, while ensuring Ms. Sharma understands the importance of accuracy for the claims assessment. Correct answer is D. Conduct a direct, fact-focused interview, clearly stating the need for precise details regarding the fire's origin and the inventory of lost items, while ensuring Ms. Sharma understands the importance of accuracy for the claims assessment. Explanation. This scenario presents a professional challenge due to the inherent power imbalance between an insurance investigator and a claimant who has suffered a significant loss. The claimant may be experiencing emotional distress, financial hardship, and a lack of understanding of the claims process, making them vulnerable. The investigator's duty is to gather accurate information to assess the claim fairly and efficiently, while also upholding ethical standards and regulatory compliance. This requires a delicate balance of assertiveness in information gathering and empathy in claimant interaction. The investigator must navigate potential biases, ensure the claimant's rights are respected, and avoid any actions that could be construed as undue pressure or misrepresentation, all within the framework of the Financial Conduct Authority, FCA Conduct of Business Sourcebook, COBS, and the principles of fair treatment of customers. The correct approach involves conducting a structured, empathetic, and fact-finding interview. This means clearly explaining the purpose of the interview, the information required, and the claimant's rights, including the right to have a representative present. The investigator should ask open-ended questions to encourage detailed responses, actively listen, and probe for clarification without leading the claimant. This method ensures comprehensive data collection while respecting the claimant's dignity and fostering trust, aligning with FCA principles of acting with integrity and in the best interests of the customer. An incorrect approach would be to adopt an aggressive or accusatory tone. This could intimidate the claimant, leading to incomplete or inaccurate information, and potentially breach FCA principles of treating customers fairly. It could also create a perception of bad faith, damaging the insurer's reputation and potentially leading to regulatory scrutiny. Another incorrect approach is to focus solely on obtaining a signed statement without ensuring the claimant fully understands its contents or has had the opportunity to ask questions. This could lead to a statement that does not accurately reflect the claimant's account, potentially disadvantaging them and failing to meet the insurer's obligation to conduct a thorough investigation. It also risks a breach of COBS requirements regarding clear communication and ensuring customers understand the implications of their actions. A third incorrect approach is to dismiss the claimant's emotional state and focus only on the technical aspects of the claim. While factual accuracy is paramount, ignoring the claimant's distress can hinder effective communication and create an adversarial relationship. This fails to uphold the principle of treating customers fairly, as it does not acknowledge the vulnerable position a claimant may be in. The professional decision-making process for similar situations should involve a pre-interview assessment of the claimant's likely state, preparation of clear and concise questions, and a commitment to active listening and empathetic communication. Investigators should be trained to recognize signs of distress and adapt their approach accordingly, always prioritizing fairness, transparency, and regulatory compliance. The goal is to gather necessary information for a fair assessment while ensuring the claimant feels heard and respected throughout the process. Question 5. When evaluating an insurance policy renewal where the policyholder has missed a premium payment deadline, and the insurer offers to waive the associated late payment fee in exchange for immediate payment of the outstanding premium, what is the correct assessment of the legal standing of this agreement under UK contract law principles relevant to insurance claims? Option A. The insurer's waiver of the late payment fee is not legally binding, because the insurer is not receiving any additional financial benefit beyond what was originally contracted. Option B. The insurer's waiver of the late payment fee is legally binding because the policyholder's immediate payment of the outstanding premium constitutes valid consideration for the insurer's promise. Option C. The insurer's waiver of the late payment fee is not legally binding as the policyholder was already obligated to pay the premium, and therefore, their payment does not constitute new consideration. Option D. The insurer's waiver of the late payment fee is legally binding because the policyholder has a history of timely payments on previous premiums. The correct answer is B. The insurer's waiver of the late payment fee is legally binding because the policyholder's immediate payment of the outstanding premium constitutes valid consideration for the insurer's promise. Explanation. This scenario presents a professional challenge because it requires the claims handler to distinguish between a genuine change in circumstances that might affect the consideration for a contract and a situation where one party is attempting to unilaterally alter the terms without providing new, legally sufficient consideration. The core of the challenge lies in identifying whether the insurer's promise to waive a late payment fee in exchange for the policyholder's agreement to pay the outstanding premium immediately constitutes valid consideration. This requires a deep understanding of contract law principles as applied within the UK regulatory framework governing insurance. The correct approach involves recognizing that the policyholder's immediate payment of the outstanding premium is a new detriment they are undertaking and a benefit to the insurer in exchange for the insurer's promise to waive the late fee. This mutual exchange of new promises or actions, where each party gives something of value or suffers a detriment, constitutes valid consideration. Under UK contract law, consideration must be sufficient but need not be adequate. The immediate payment of a debt already due, while not necessarily adequate in a commercial sense if the fee were substantial, is legally sufficient as it represents a new act or forbearance by the policyholder. This aligns with the principles of contract formation and enforcement as understood within the UK legal system and relevant insurance regulations. An incorrect approach would be to assume that because the premium was already due, the policyholder's payment is merely fulfilling an existing obligation and therefore cannot serve as consideration for the insurer's waiver. This overlooks the fact that the waiver is a new promise made in exchange for the immediate payment, not just payment at some point. Another incorrect approach would be to focus solely on the insurer's potential loss of the late fee, rather than the mutual exchange of promises. The insurer's willingness to forego the fee is a concession made in return for the policyholder's prompt action. A further incorrect approach might be to consider the policyholder's past payment of premiums as the consideration for the waiver, which is legally unsound as past consideration is generally not valid consideration for a new promise. Professionals should approach such situations by first identifying the promises made by each party. Then, they must assess whether each promise is supported by valid consideration. This involves determining if there is a mutual exchange of something of value or a detriment suffered by each party in relation to the new promise. If valid consideration exists, the agreement is likely enforceable. If not, the insurer's promise may be gratuitous and unenforceable, requiring the original terms to be upheld. This analytical process, grounded in contract law principles relevant to the UK jurisdiction, ensures fair and legally compliant claims handling. Question 6. Governance review demonstrates that a claims investigator is handling a complex policyholder claim involving potential mis-selling. The investigator has received initial documentation from the policyholder, but requires further information to verify the circumstances of the policy's inception. The investigator is considering several methods to obtain this information. Which of the following represents the most appropriate and compliant approach for the investigator to adopt? Option A. Sending a formal request to the policyholder for specific financial statements and correspondence from the period in question, clearly explaining why this information is necessary for the claim investigation and outlining data protection measures. Option B. Contacting the policyholder's employer to discreetly inquire about their financial stability at the time the policy was taken out, without informing the policyholder. Option C. Relying solely on publicly available credit reports to infer the policyholder's financial situation and making a provisional decision on the claim. Option D. informing the policyholder that their claim is unlikely to be successful due to insufficient evidence, and offering a significantly reduced settlement to expedite closure. The correct answer is B. Contacting the policyholder's employer to discreetly inquire about their financial stability at the time the policy was taken out, without informing the policyholder. Explanation: this scenario presents a professional challenge because it requires the claims investigator to balance the need for thoroughness in gathering evidence with the imperative to act ethically and in compliance with regulatory requirements, specifically the FCA's principles for businesses and CONC rules relevant to consumer credit claims. The investigator must avoid actions that could be construed as misleading or unfair to the policyholder, while still fulfilling their duty to investigate the claim accurately. The pressure to resolve claims efficiently must not compromise the integrity of the investigation process or the fair treatment of the customer. The correct approach involves a systematic and documented process of evidence gathering, including requesting specific documentation from the policyholder and third parties, and clearly communicating the purpose and necessity of these requests. This aligns with the regulatory expectation for firms to act with integrity, skill, care, and diligence, and to treat customers fairly. Specifically, it upholds the principle of transparency in dealings with customers and ensures that decisions are based on a comprehensive understanding of the facts, as required by FCA principles and relevant CONC provisions concerning information provision and complaint handling. An incorrect approach that involves making assumptions about the policyholder's financial situation without direct evidence or requesting information in a manner that could be perceived as intrusive or accusatory would be professionally unacceptable. This would likely breach the FCA's principle of treating customers fairly, as it could lead to an inaccurate assessment of the claim and potentially disadvantage the policyholder. Furthermore, failing to document the rationale for information requests or the investigation steps taken would undermine the firm's ability to demonstrate compliance during regulatory scrutiny or internal audits, violating principles of good governance and record-keeping. Another incorrect approach, such as prematurely closing the investigation based on incomplete information to meet internal targets, would directly contravene the duty of care and diligence owed to the policyholder and could lead to an unfair outcome, failing to meet regulatory standards for claims handling. Professionals should adopt a decision-making framework that prioritizes a clear understanding of the regulatory obligations, a commitment to fair treatment of customers, and a structured, evidence-based investigation process. This involves 1. Identifying the specific regulatory requirements applicable to the claim type and jurisdiction. 2. Developing a clear investigation plan that outlines necessary evidence and information sources. 3. Communicating transparently and respectfully with the policyholder and any relevant third parties. 4. Meticulously documenting all steps taken, communications, and evidence gathered. And 5. Critically evaluating the evidence to reach a fair and compliant decision, with a willingness to revisit assumptions if new information emerges. Question 7. The efficiency study reveals that the claims handling team is experiencing delays in obtaining crucial evidence for complex property damage claims. A claims handler is reviewing a claim for water damage to a dwelling. Which of the following approaches to gathering evidence is most aligned with regulatory expectations for thoroughness and fairness? Option A. Demanding that the policyholder provide a full architectural plan of the property and detailed historical maintenance records, regardless of the claim's nature. Option B. Accepting the policyholder's verbal assurance that the damage is extensive and proceeding with settlement based on an estimated repair cost. Option C. Asking the policyholder to provide a general overview of the damage and accepting any readily available, unverified images they might have on their phone. Option D. Requesting a detailed report from a qualified loss adjuster, comprehensive photographic evidence of the damage from various angles, and relevant invoices for any immediate remedial work undertaken by the policyholder. The correct answer is D. Requesting a detailed report from a qualified loss adjuster, comprehensive photographic evidence of the damage from various angles, and relevant invoices for any immediate remedial work undertaken by the policyholder. Explanation: the efficiency study reveals that the claims handling team is experiencing delays in obtaining crucial evidence for complex property damage claims. This scenario is professionally challenging because the pressure to expedite claims processing can conflict with the thoroughness required to gather accurate and comprehensive evidence. Striking the right balance is essential to ensure fair settlements, prevent fraud, and maintain regulatory compliance. The claims handler must exercise careful judgment in selecting and evaluating evidence, understanding that incomplete or improperly obtained evidence can lead to disputes, financial losses, and reputational damage. The correct approach involves a systematic and documented process for gathering evidence, prioritizing accuracy and relevance. This includes clearly defining the types of documents, photographs, and videos needed based on the claim's specifics, and ensuring that all collected evidence is relevant, verifiable, and obtained in a manner that respects privacy and legal boundaries. For instance, requesting specific invoices for repairs, detailed photographic evidence of the damage from multiple angles, and video footage of the incident or its immediate aftermath, if available and relevant, are all standard and appropriate. This methodical approach aligns with the principles of good claims handling, which emphasize due diligence and fair treatment of the policyholder, as mandated by regulatory bodies like the Financial Conduct Authority, FCA, in the UK, which expects firms to treat customers fairly and handle claims promptly and efficiently. An incorrect approach would be to rely solely on the policyholder's verbal description of the damage, without seeking corroborating documentary or visual evidence. This fails to meet the due diligence requirements and opens the door to potential misrepresentation or exaggeration of the claim. Another incorrect approach is to accept generic, unverified photographs or videos that do not clearly depict the claimed damage or its cause. This demonstrates a lack of critical evaluation and could lead to an overpayment or an underpayment, both of which are detrimental. Furthermore, pressuring the policyholder to provide evidence that is disproportionate to the claim's value or intrusive to their privacy would be an ethical and regulatory failure, potentially breaching data protection laws and the FCA's principles of treating customers fairly. The professional decision-making process for similar situations should involve a risk-based assessment. Claims handlers should first identify the key pieces of evidence required to validate the claim's circumstances and quantum. They should then consider the most efficient and appropriate methods for obtaining this evidence, always adhering to legal and ethical standards. This includes maintaining clear communication with the policyholder, explaining the evidence requirements, and offering assistance where appropriate. Regular training on evidence-gathering techniques and regulatory expectations is also crucial to ensure consistent and compliant claims handling. Question 8. Regulatory review indicates that a claims handler has received a request from a policyholder's solicitor for detailed personal information pertaining to the policyholder's medical history, which is relevant to a current claim. The solicitor states this information is required to assess the validity of the claim. What is the most appropriate course of action for the claims handler, adhering strictly to UK data protection regulations? Option A. Verify the solicitor's identity and authority. Confirm the specific data required is necessary and proportionate for claim assessment under a lawful basis, e.g., contract performance or legal obligation, and provide only that necessary data, potentially with appropriate redactions or anonymization if feasible and sufficient. Option B. Refuse to provide any information, citing data privacy concerns, and inform the solicitor that no personal data can be shared. Option C. Attempt to anonymize the entire medical history record before sending it to the solicitor, assuming this will satisfy data privacy requirements. Option D. Provide all requested medical history details to the solicitor, as the request comes from a legal representative and is stated to be for claim assessment. The correct answer is D. Provide all requested medical history details to the solicitor, as the request comes from a legal representative and is stated to be for claim assessment. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent tension between a client's desire for swift resolution and the insurer's obligation to protect sensitive personal data. The claims handler must navigate the legal requirements of data privacy while also meeting service-level expectations and maintaining client trust. The complexity arises from identifying what constitutes personal data in the context of a claim, understanding the lawful basis for processing it, and ensuring appropriate security measures are in place, all within the strict confines of UK data protection law. Correct approach analysis. The correct approach involves a thorough understanding of the UK General Data Protection Regulation, UK GDPR, and the Data Protection Act 2018. Specifically, it requires the claims handler to identify the specific personal data being requested, Determine the lawful basis for processing that data, e.g., necessity for the performance of a contract, legal obligation, or legitimate interests, and ensure that the disclosure is necessary and proportionate to the stated purpose. This approach prioritizes compliance with data protection principles, such as data minimization and purpose limitation, while still aiming to facilitate the claim's progression in a legally sound manner. It demonstrates professional integrity by upholding legal duties and safeguarding individual privacy. Incorrect approaches analysis, providing all requested information without verification, fails to acknowledge the insurer's legal duty to protect personal data. This approach risks unlawful disclosure of sensitive information, potentially leading to breaches of the UK GDPR, regulatory fines from the Information Commissioner's Office (ICO), and reputational damage. It disregards the principles of data minimization and purpose limitation, as not all information may be relevant or necessary for the client's stated purpose. Refusing to provide any information based on a blanket interpretation of data privacy laws is also professionally unacceptable. While data protection is crucial, it should not create an insurmountable barrier to legitimate claim processing. Such an approach would likely breach contractual obligations to the client and fail to act with reasonable skill and care, potentially leading to client dissatisfaction and complaints. It overlooks the lawful basis for processing and sharing data when it is necessary for the performance of the insurance contract or to meet legal obligations. Seeking to anonymize the data without understanding the specific context of the request is an insufficient measure. True anonymization, which renders data irreversibly unidentifiable, is often difficult to achieve and may not be appropriate if the recipient requires specific details to assess the claim. This approach might lead to the provision of incomplete or misleading information, hindering the claim's progress and failing to meet the underlying need for specific data. Professional reasoning. Professionals in this situation should adopt a structured decision-making process. First, they must clearly identify the specific data requested and the purpose for which it is needed. Second, they should consult the relevant data protection legislation, UK GDPR and Data Protection Act 2018, to determine the lawful basis for processing and sharing that data. Third, they must assess whether the disclosure is necessary and proportionate to the stated purpose, applying principles like data minimization. If the request is legitimate but requires careful handling, professionals should explore options such as providing only the essential data, redacting irrelevant information, or obtaining explicit consent where appropriate, always documenting their decision-making process. Question 9. Cost-benefit analysis shows that a quick settlement of a motor insurance claim, based on the initial report of minor damage, would save the insurer significant administrative costs and expedite customer satisfaction in the short term. However, further investigation might reveal underlying structural issues not immediately apparent, potentially increasing the claim value substantially. What is the most appropriate claims handling approach in this scenario? Adhering strictly to the FCA's Conduct of Business Sourcebook (COBS) and the principles of treating customers fairly. Option A. Proceed with a settlement offer based on the initial report of minor damage to achieve immediate cost savings and customer expediency. Option B. Advise the policyholder that the claim is complex and may take an extended period to resolve due to the potential for underlying issues, without initiating immediate investigative steps. Option C. Conduct a thorough investigation, including obtaining expert reports if necessary, to accurately assess the full extent of the damage and determine the appropriate settlement amount, even if it incurs higher initial costs and takes longer. Option D. Offer a provisional settlement based on the initial report, with a clause stating that the offer may be revised pending further investigation, to balance expediency with potential accuracy. The correct answer is A. Proceed with a settlement offer based on the initial report of minor damage to achieve immediate cost savings and customer expediency. Explanation. This scenario presents a professional challenge because it requires balancing the insurer's need for efficient claims handling with the policyholder's right to a fair and timely settlement, all within the strict confines of the Financial Conduct Authority, FCA, Conduct of Business Sourcebook (COBS), and the principles of fair treatment of customers. The complexity arises from interpreting and applying the fair and reasonable settlement principle in a situation where initial information might suggest a lower payout, but further investigation could reveal a higher liability. The correct approach involves a thorough and objective investigation of the claim, gathering all relevant evidence, and considering all policy terms and conditions before making a settlement offer. This aligns with COB 6, 1A, 4R, which mandates that firms must act honestly, fairly, and professionally in accordance with the best interests of their clients. Specifically, it requires a claims handler to assess the claim based on all available information and policy provisions, ensuring the settlement reflects the true extent of the insurer's liability. This proactive and comprehensive approach prevents underpayment and upholds the insurer's duty of care. An incorrect approach would be to settle the claim based solely on the initial, potentially incomplete, information provided by the policyholder, without undertaking further investigation. This fails to meet the standard of acting honestly, fairly, and professionally, as it risks prejudicing the policyholder by offering a settlement that does not reflect the full scope of their entitlement under the policy. It also contravenes the principle of treating customers fairly, as it prioritizes expediency over accuracy and fairness. Another incorrect approach would be to delay the settlement unnecessarily, citing ongoing investigations without a clear and justifiable reason. This would violate COB 6, 1A, 4R's requirement to act in the best interests of the client, and could lead to a breach of the FCA's principles regarding timely claims handling, causing undue distress and financial hardship to the policyholder. A further incorrect approach would be to offer a settlement that is demonstrably lower than what the policy terms and evidence suggest, with the implicit aim of encouraging the policyholder to accept a quicker, albeit smaller, payout. This is unethical and a clear breach of regulatory requirements, as it constitutes an unfair practice and fails to treat the customer honestly and fairly. Professional decision-making process for similar situations should involve a systematic review of the claim against policy terms, a commitment to gathering all necessary evidence, and an objective assessment of liability. Professionals must always prioritize the fair treatment of customers, ensuring that settlements are accurate, timely, and reflect the insurer's obligations. When in doubt, seeking clarification from senior colleagues or legal counsel is a prudent step. Question 10. The evaluation methodology shows that a claims handler, upon receiving a notification of a significant property damage claim, has reviewed the initial submission and identified several areas where the insured's description of events appears incomplete, particularly concerning the timeline and the presence of specific safety measures that might be relevant to the cause of the damage. The handler is considering how to proceed. Which of the following represents the most appropriate course of action under the principle of utmost good faith? Option A. Accepting the claim at face value without further investigation, as the insured has provided an initial notification, and further questioning might be perceived as adversarial. Option B. Requesting further detailed information from the insured regarding the identified gaps in the timeline and the specific safety measures, explaining the relevance of this information to the claim assessment. Option C. Contacting third-party sources to gather information about the insured's property and the incident without informing the insured, to verify the incomplete details. Option D. Assuming the insured has intentionally omitted material facts due to the initial incompleteness and proceeding to reject the claim based on a breach of utmost good faith. The correct answer is B. Requesting further detailed information from the insured regarding the identified gaps in the timeline and the specific safety measures, explaining the relevance of this information to the claim assessment. Explanation. This scenario is professionally challenging because it requires the claims handler to balance the insurer's need for accurate information with the insured's duty of disclosure, all within the framework of utmost good faith. The core difficulty lies in determining the extent of information that must be proactively disclosed by the insured, especially when the insured may not fully understand their obligations or the significance of certain details. Careful judgment is required to avoid prejudicing the claim unfairly while still upholding the principles of the insurance contract. Correct approach involves a thorough and objective investigation of the circumstances surrounding the claim, coupled with a clear and transparent communication process with the insured. This means actively seeking all relevant information, including details that might not be immediately apparent or volunteered by the insured, without making assumptions or prejudging the validity of the claim. The insurer has a duty to act in good faith by conducting a fair and impartial assessment, and this includes making reasonable inquiries to clarify any ambiguities or potential omissions. Regulatory guidance, such as that found in the FCA's Conduct of Business Sourcebook, COBS, and General Principles of Contract Law in the UK, emphasizes the need for insurers to treat customers fairly and to handle claims promptly and honestly. The principle of utmost good faith, ubermi fide, underpins the entire insurance contract, requiring both parties to act with complete honesty and to disclose all material facts. Therefore, a proactive and fair investigation aligns with these fundamental principles. An incorrect approach would be to assume the insured has intentionally withheld information simply because certain details were not immediately provided. This prejudges the insured's intent and fails to acknowledge that omissions can be unintentional or due to a lack of understanding. Such an approach could lead to a breach of the duty of utmost good faith by unfairly challenging the claim without proper investigation. Another incorrect approach would be to accept the claim without further inquiry, even if there are clear indications of material facts that have not been disclosed. This would undermine the principle of utmost good faith by failing to ensure the insurer has a complete and accurate picture upon which to base their decision, potentially leading to claims being settled on incorrect terms or for amounts not truly warranted by the disclosed facts. Professionals should adopt a decision-making framework that prioritizes a fair and thorough investigation. This involves 1. Understanding the policy terms and conditions thoroughly. 2. Conducting a comprehensive review of all submitted documentation. 3. Identifying any gaps or potential areas of concern that require further clarification. 4. Communicating clearly and respectfully with the insured, explaining what information is needed and why. 5. Making reasonable inquiries to gather all material facts. 6. Evaluating the information objectively against the policy terms and the circumstances of the loss. 7. Making a decision based on the complete and accurate picture, adhering to regulatory requirements and ethical principles. Question 11. Stakeholder feedback indicates a need to refine our understanding of risk classification within the claims assessment process. A recent large-scale event has led to a significant increase in claims related to widespread supply chain disruptions, impacting the availability and cost of essential repair materials for insured properties. The insurer is experiencing a surge in claims where policyholders are facing prolonged repair times and increased out-of-pocket expenses due to these external factors. Which of the following approaches best categorizes the primary risk presented by this situation for the insurer? Option A. Classifying the risk as pure, as there is no possibility of financial gain for the insurer, only the potential for loss. Option B. Classifying the risk as fundamental, as it affects a broad segment of the insured population and is driven by systemic economic and logistical factors beyond individual control. Option C. Classifying the risk as particular, as each claim is unique to an individual policyholder's property and repair needs. Option D. Classifying the risk as speculative, as the insurer could potentially profit from increased premiums if the market demands higher coverage for such events. The correct answer is B. Classifying the risk as fundamental, as it affects a broad segment of the insured population and is driven by systemic economic and logistical factors beyond individual control. Explanation. This scenario is professionally challenging because it requires the claims assessor to distinguish between different types of risk to accurately assess the potential impact and appropriate response. Misclassifying risk can lead to incorrect reserve setting, inadequate mitigation strategies, and ultimately, financial losses for the insurer and dissatisfaction for the policyholder. Careful judgment is required to apply theoretical risk classification to a practical claims scenario. The correct approach involves identifying the risk as fundamental. Fundamental risks are those that affect a large segment of the population or economy, such as widespread economic downturns or natural disasters. They are typically beyond the control of individual policyholders and often have systemic causes. Recognizing this as a fundamental risk means the insurer must consider its broader implications for the portfolio and potentially its reinsurance arrangements, rather than focusing solely on individual policyholder actions. This aligns with regulatory expectations for robust risk management frameworks that consider systemic risks and their potential impact on solvency and policyholder protection. An incorrect approach would be to classify the risk as speculative. Speculative risks involve the possibility of gain or loss, such as investing in the stock market. In an insurance context, this classification would be inappropriate, as the scenario describes a situation with only the potential for loss, not gain. This misclassification would lead to an incorrect assessment of the risk's nature and the insurer's exposure. Another incorrect approach would be to classify the risk as particular. Particular risks are those that affect only an individual or a small group of individuals and are often within their control, such as a house fire due to faulty wiring. While the specific claim might have particular elements, the underlying cause described in the scenario is broader. Treating it solely as a particular risk would lead to an underestimation of the potential for widespread claims and a failure to implement appropriate portfolio-level risk management strategies. The professional decision-making process for similar situations should involve a systematic evaluation of the risk's characteristics. First, determine if the risk presents an opportunity for gain or only for loss, pure vs. speculative. Second, assess the scope and origin of the risk. Does it affect a broad population or a specific individual/group, fundamental vs. particular? By applying these distinctions, professionals can accurately categorize risks, enabling them to implement appropriate claims handling, reserving, and risk mitigation strategies that comply with regulatory requirements for prudent financial management and policyholder protection. Question 12. Research into a motor insurance claim has revealed that the insured driver, an employee, was involved in an accident while driving a company vehicle. The accident occurred during working hours, but the employee claims they were on a personal errand at the time, deviating from their usual work route. The third-party claimant is now seeking damages from both the employee and their employer, alleging negligence on the part of the employee. What is the most appropriate approach for the claims handler to adopt in assessing the employer's potential vicarious liability? Option A. Conduct a detailed investigation into the employee's specific duties, the employer's policies regarding vehicle use, and whether the employee's actions, even if on a personal errand, were sufficiently connected to their employment to fall within the course and scope of employment, considering the employer's potential benefit or authorization. Option B. Accept full liability for the employer based on the fact that a company vehicle was involved and the accident occurred during working hours, without further investigation into the employee's actions. Option C. Advise the claimant to pursue their claim solely against the employee's personal motor insurance, as the employer cannot be held liable for an employee's personal activities. Option D. Immediately deny any claim against the employer, asserting that the employee was on a personal errand and therefore acting outside the scope of their employment, regardless of the circumstances. The correct answer is A. Conduct a detailed investigation into the employee's specific duties, the employer's policies regarding vehicle use, and whether the employee's actions, even if on a personal errand, were sufficiently connected to their employment to fall within the course and scope of employment, considering the employer's potential benefit or authorization. Explanation. This scenario presents a professional challenge because it requires the claims handler to navigate the complexities of vicarious liability in a situation where the primary insured's actions may have inadvertently caused harm to a third party, and the insured's employer is now being implicated. The challenge lies in accurately assessing the scope of employment and the employer's potential responsibility, which can have significant financial and reputational consequences for all parties involved. Careful judgment is required to distinguish between an employee acting within the course and scope of their employment and acting on a frolic of their own, a distinction crucial for determining vicarious liability. The correct approach involves a thorough investigation into the specific duties and responsibilities of the employee at the time of the incident, and whether their actions were undertaken in furtherance of their employer's business. This requires gathering evidence such as employment contracts, company policies, witness statements, and any relevant operational procedures. The regulatory framework, specifically the principles of agency and employment law as interpreted by UK courts, dictates that an employer is vicariously liable for the torts committed by their employees if those torts are committed in the course of employment. This means the employee was doing something they were employed to do, or something incidental to it, and that the employer benefited from or authorized the activity, even if the specific act was unauthorized or wrongful. Adhering to this approach ensures compliance with legal obligations and fair claims handling. An incorrect approach would be to automatically deny coverage for the third-party claim simply because the employee was acting negligently. This fails to recognize that an employer can be held liable for an employee's negligence if it occurs within the scope of employment. Another incorrect approach would be to accept full liability for the employer without a detailed investigation into the employee's actions and their connection to their employment duties. This could lead to an unwarranted payout and potentially expose the insurer to subrogation claims if the employee was solely at fault and acting outside their employment. A further incorrect approach would be to rely solely on the employee's personal insurance, ignoring the potential for vicarious liability on the part of the employer, which is a separate and distinct legal concept. Each of these incorrect approaches fails to uphold the principles of accurate claims assessment and adherence to the legal principles governing vicarious liability. Professional decision-making in such situations requires a systematic process. First, clearly identify the insured party and the claimant. Second, understand the nature of the alleged harm and the circumstances under which it occurred. Third, investigate the relationship between the individual who caused the harm and any potential principal or employer, focusing on the scope of authority and employment. Fourth, consult relevant legal precedents and regulatory guidance on vicarious liability. Finally, make a determination based on the gathered evidence and legal principles, communicating the decision clearly and transparently to all parties. Question 13. To address the challenge of efficiently and compliantly managing a portfolio of policies approaching renewal, where the insurer has identified a need to non-renew certain risks due to evolving underwriting criteria, what is the most appropriate process optimization strategy? Option A. Defer the non-renewal decision for borderline cases until the absolute last moment before the renewal date to allow for further observation of the policyholder's risk profile. Option B. Implement a proactive, data-driven review of each policy against updated underwriting guidelines, ensuring timely and transparent communication of non-renewal reasons and notice periods to affected policyholders, with a focus on providing guidance for alternative market options where feasible. Option C. Rely on a general statement of changing market conditions in all non-renewal notices to avoid lengthy individual explanations and potential disputes. Option D. Immediately issue non-renewal notices to all policies flagged by the system as potentially exceeding new risk thresholds, without detailed individual review, to expedite the portfolio adjustment. The correct answer is B. Implement a proactive, data-driven review of each policy against updated underwriting guidelines, ensuring timely and transparent communication of non-renewal reasons and notice periods to affected policyholders, with a focus on providing guidance for alternative market options where feasible. Explanation. This scenario is professionally challenging because it requires balancing the insurer's right to manage its risk portfolio with the policyholder's expectation of continuity of cover and fair treatment. The insurer must navigate the regulatory requirements surrounding non-renewal, ensuring that any decision is not arbitrary, discriminatory, or in breach of consumer protection principles. The core of the challenge lies in implementing a process that is both efficient for the insurer and transparent, and compliant with the regulatory framework for the policyholder. The correct approach involves a systematic review of the policyholder's risk profile against the insurer's underwriting guidelines and risk appetite, coupled with a clear, documented rationale for the non-renewal decision. This approach ensures that the decision is based on objective criteria and is justifiable under the relevant regulations. Specifically, it necessitates providing adequate notice to the policyholder, clearly stating the reasons for non-renewal, and offering guidance on alternative options where legally or contractually required. This aligns with the regulatory emphasis on fairness, transparency, and the duty of care owed to policyholders, preventing arbitrary cancellations or non-renewals that could lead to consumer detriment or regulatory sanctions. An incorrect approach involving immediate cancellation without proper notice or clear justification would violate the policy terms and regulatory requirements for termination of insurance contracts. This failure to provide adequate notice and a reasoned explanation exposes the insurer to potential claims of unfair treatment and breach of contract, and could result in regulatory penalties for noncompliance with consumer protection legislation. Another incorrect approach, such as relying solely on a broad, unspecific reason for non-renewal without detailed supporting evidence, would also be professionally unacceptable. Regulators expect insurers to be able to substantiate their decisions with concrete data and underwriting principles. A vague justification undermines the transparency expected in insurance practices and leaves the policyholder without a clear understanding of the issues, hindering their ability to seek alternative cover or address any underlying concerns. This lack of specificity can be interpreted as a failure to act in good faith. Finally, an approach that prioritizes administrative expediency over policyholder communication, such as failing to inform the policyholder of the non-renewal until the last possible moment, not providing any information about alternative market options, would be ethically and regulatorily unsound. This demonstrates a disregard for the policyholder's need for continuity of insurance and their potential vulnerability in the market. Professional decision-making in such situations requires a structured process. First, thoroughly understanding the policy terms and the applicable regulatory framework. Second, objectively assessing the policyholder's risk against established underwriting criteria. Third, documenting the decision-making process and the rationale. And fourth, communicating the decision and its reasons to the policyholder in a clear, timely, and compliant manner, while also considering any obligations to assist the policyholder in finding alternative cover where appropriate. Question 14. Analysis of the most appropriate method for advising a claimant on settlement options, considering their potential vulnerability and the long-term implications of their choice, requires careful consideration of regulatory obligations and ethical duties. Which of the following best reflects the professional approach to guiding a claimant through the decision between a lump sum settlement and a structured settlement? Option A. Advocating for a structured settlement as it provides long-term financial security and reduces the risk of the claimant mismanaging a large sum of money, regardless of their expressed preferences. Option B. Providing a clear explanation of both lump sum and structured settlement options, including their respective benefits, drawbacks, and suitability for different claimant needs, while actively assessing the claimant's capacity to manage a lump sum and encouraging them to seek independent advice if necessary. Option C. Recommending a lump sum settlement as it offers immediate financial flexibility, assuming the claimant will seek independent financial advice to manage the funds effectively. Option D. Presenting a detailed comparison of the tax implications and potential investment growth of a lump sum versus the guaranteed income stream, and tax advantages of a structured settlement, allowing the claimant to choose based on their financial acumen and risk tolerance. The correct answer is D. Presenting a detailed comparison of the tax implications and potential investment growth of a lump sum versus the guaranteed income stream and tax advantages of a structured settlement, allowing the claimant to choose based on their financial acumen and risk tolerance. Explanation. This scenario presents a professional challenge because it requires balancing the claimant's immediate financial needs and long-term security with the insurer's obligations and the regulatory environment governing settlement practices. The core difficulty lies in advising a claimant on the most suitable settlement option when their capacity to manage a large lump sum is uncertain and their future needs are not fully defined. This necessitates a deep understanding of the claimant's circumstances, a thorough grasp of the available settlement mechanisms, and adherence to principles of good faith and fair dealing. The correct approach involves a comprehensive assessment of the claimant's needs, vulnerabilities, and preferences, followed by a detailed explanation of both lump sum and structured settlement options, highlighting the advantages and disadvantages of each in relation to the claimant's specific situation. This approach prioritizes the claimant's best interests by ensuring they are fully informed and empowered to make a decision that aligns with their long-term well-being. Regulatory frameworks, such as those governing insurance claims handling and consumer protection, mandate that insurers act in good faith and provide clear, accurate information to claimants. Ethically, this translates to a duty of care and a commitment to transparency. An incorrect approach would be to unilaterally push for a lump sum settlement without adequate consideration of the claimant's ability to manage the funds, potentially leading to financial mismanagement and future hardship for the claimant. This would breach the duty of good faith and fair dealing, as it prioritizes expediency or cost saving for the insurer over the claimant's welfare. Another incorrect approach would be to solely advocate for a structured settlement without exploring the claimant's desire for immediate access to capital or their capacity to invest and manage funds independently, thereby potentially limiting their autonomy and financial flexibility unnecessarily. This could be seen as failing to adequately consider the claimant's individual circumstances and preferences, potentially leading to a settlement that does not meet their overall needs. The professional decision-making process should involve a structured dialogue with the claimant, starting with active listening to understand their concerns and aspirations. This should be followed by a clear exposition of the settlement options, using plain language and avoiding jargon. The claimant should be encouraged to ask questions and given sufficient time to consider their options. Where appropriate, and with the claimant's consent, seeking input from financial advisors or legal representatives can further support their decision-making process. The ultimate goal is to facilitate an informed and voluntary decision by the claimant that best serves their long-term interests, in compliance with all applicable regulations and ethical standards. Question 15. The investigation demonstrates that a claims handler, under pressure to reduce average claim settlement times, is considering approving a claim for accidental damage, or the policy contains a specific exclusion for damage caused by wear and tear. The claimant has provided a statement attributing the damage solely to an accidental event, but the handler notes some visual indicators that could suggest gradual deterioration over time. The handler is contemplating waiving the need for further technical assessment to expedite the settlement. Option A. Expedite the claim by approving it immediately, and then initiate a retrospective review to see if the wear and tear exclusion was indeed applicable, with the intention of recovering funds if it was not. Option B. Inform the claimant that the claim is likely to be denied due to the wear and tear exclusion, and offer a significantly reduced settlement to avoid further investigation costs. Option C. Proceed with a full assessment of the damage, including obtaining expert opinion if necessary, to determine if the wear and tear exclusion is applicable, and communicate the findings clearly to the policyholder. Option D. Approve the claim based on the claimant's statement and the desire to meet settlement time targets, without further investigation into the potential wear and tear exclusion. The correct answer is C. Proceed with a full assessment of the damage, including obtaining expert opinion if necessary, to determine if the wear and tear exclusion is applicable, and communicate the findings clearly to the policyholder. Explanation. The investigation demonstrates a scenario where a claims handler faces conflicting pressures, the need for efficient claims processing, and the imperative to uphold ethical standards and regulatory compliance. This creates a professional challenge, because the handler must balance the company's operational goals with their duty to the policyholder and the integrity of the claims process. The temptation to expedite a claim by overlooking minor discrepancies, even if seemingly insignificant, can lead to regulatory breaches and damage professional reputation. Careful judgment is required to ensure that expediency does not compromise fairness, accuracy, or adherence to the principles of good faith and fair dealing. The correct approach involves a thorough review of all submitted documentation, including the policy wording and any supporting evidence, to ensure that the claim meets all policy conditions and is assessed accurately and fairly. This approach prioritizes adherence to the Insurance Conduct of Business Sourcebook (ICOB's) principles, particularly those relating to treating customers fairly and providing clear, accurate, and not misleading information. It also aligns with the broader ethical duty of a claims handler to act with integrity and diligence, ensuring that the policyholder receives what they are contractually entitled to, without undue delay or unfair denial. This method upholds the trust placed in the insurance profession and maintains the company's reputation for fair claims handling. An incorrect approach that involves accepting the claimant's word without verifying the provided details, despite a policy exclusion that appears to be triggered, fails to uphold the principle of fair dealing. This could lead to a payout that is not contractually obligated, potentially resulting in financial loss for the insurer and setting a precedent for future claims. It also risks misleading the policyholder about the extent of their cover. Another incorrect approach, which is to delay the claim unnecessarily to pressure the claimant into accepting a lower settlement, is a direct contravention of ICOB's requirements regarding fair treatment and avoiding undue delay. This behavior erodes trust and can lead to regulatory sanctions. Finally, an approach that involves selectively presenting policy terms to the claimant to justify a denial, while omitting other relevant clauses that might support their claim, is unethical and misleading, violating the duty to act with transparency and in good faith. The professional decision-making process for similar situations should involve a systematic evaluation of the claim against the policy terms and relevant regulations. This includes identifying any potential conflicts or ambiguities, seeking clarification where necessary, and documenting all decisions and justifications thoroughly. Professionals should always err on the side of caution when ethical considerations are involved, prioritizing fairness and compliance over expediency. If unsure, seeking guidance from senior colleagues or legal counsel is a crucial step in ensuring the correct and ethical resolution of a claim. Question 16. During the evaluation of a motor insurance claim where the policyholder alleges the other party was solely at fault for a collision, what is the most appropriate approach to determining liability, considering the need for a fair and accurate assessment? Option A. Expedite the settlement process by agreeing to the policyholder's proposed liability outcome to minimize administrative costs and claimant dissatisfaction, even if all facts have not been fully ascertained. Option B. Rely primarily on the initial police report, assuming it accurately and completely assigns blame without further independent verification of the circumstances. Option C. Conduct a thorough investigation of all available evidence, including statements from all parties, independent witness accounts, and any relevant road traffic accident reports, to objectively assess the degree of fault of each party involved based on established legal principles. Option D. Accept the policyholder's account of events as conclusive and proceed with settling the claim based on their assertion of the other party's sole responsibility. The correct answer is C. Conduct a thorough investigation of all available evidence, including statements from all parties, independent witness accounts, and any relevant road traffic accident reports, to objectively assess the degree of fault of each party involved based on established legal principles. Explanation. This scenario is professionally challenging because it requires the claims handler to balance the claimant's desire for a swift resolution with the insurer's obligation to conduct a thorough and fair assessment of liability. The pressure to settle quickly, often driven by commercial considerations or claimant expectations, can lead to premature conclusions that may not be fully supported by the available evidence. A claims handler must exercise sound judgment, drawing upon their understanding of legal principles, evidential weight, and the specific circumstances of the incident, to arrive at a defensible liability determination. The correct approach involves a systematic and evidence-based assessment of liability. This means meticulously gathering all relevant facts, including witness statements, expert reports, photographic evidence, and any applicable contractual terms or statutory provisions. The handler must then critically analyze this evidence to determine the degree of fault attributable to each party involved. This analytical process should be guided by established legal principles of negligence, causation, and contributory negligence, as well as the specific terms of the policy. Regulatory frameworks, such as those governing fair claims handling practices, mandate that insurers act with due diligence and in good faith. A thorough, evidence-led approach ensures compliance with these obligations by preventing arbitrary or unsubstantiated decisions, thereby protecting both the claimant's rights and the insurer's financial integrity. An incorrect approach that relies solely on the claimant's assertion of fault without independent verification fails to meet the insurer's duty of care and regulatory obligations. This can lead to paying claims that are not legally valid, potentially resulting in financial loss and reputational damage. It also undermines the principle of fairness by not considering the potential contributory negligence of the claimant or the liability of other parties. Another incorrect approach that prematurely assigns full liability based on limited or anecdotal information, without a comprehensive review of all available evidence, is equally problematic. This demonstrates a lack of due diligence and can result in an inaccurate assessment, potentially leading to overpayment or underpayment of a claim, and failing to uphold the insurer's responsibility to assess liability objectively. A further incorrect approach that prioritizes speed of settlement over the accuracy of the liability assessment, perhaps due to internal performance targets, disregards the fundamental principles of fair claims handling. This can lead to decisions that are not legally sound, potentially exposing the insurer to future disputes and regulatory scrutiny. The professional decision-making process for similar situations should involve a structured approach. First, clearly define the scope of the investigation. Second, diligently collect all relevant evidence. Third, critically analyze the evidence against applicable legal and contractual principles. Fourth, document the reasoning for the liability determination thoroughly. And finally, communicate the decision clearly and transparently to all parties involved, adhering strictly to regulatory requirements for claims handling. Question 17. Risk assessment procedures indicate a potential for significant variation in the valuation of non-economic loss claims. When assessing compensation for pain, suffering, and loss of amenity, which approach best aligns with the regulatory framework and ethical obligations for fair claims handling? Option A. Applying a standardized, fixed compensation schedule for all injuries of a similar nature, irrespective of individual claimant circumstances. Option B. Prioritizing the reduction of claim payouts by focusing only on demonstrably quantifiable losses and dismissing subjective accounts of suffering. Option C. Relying solely on the claimant's initial statement of loss without independent verification or consideration of medical evidence. Option D. Conducting a thorough, individualized assessment that considers the claimant's specific injury, its impact on their quality of life, and relevant legal precedents, while engaging empathetically with the claimant's experience. The correct answer is A. Applying a standardized fixed compensation schedule for all injuries of a similar nature, irrespective of individual claimant circumstances. Explanation. Scenario analysis. This scenario is professionally challenging because assessing non-economic loss, such as pain and suffering, loss of amenity, and loss of enjoyment of life, is inherently subjective. Unlike economic losses, which can be quantified with financial evidence, non-economic losses require a nuanced understanding of the claimant's experience and the impact of their injuries on their quality of life. The challenge lies in balancing empathy for the claimant's situation with the need for objective, fair, and legally defensible assessments that align with established legal principles and regulatory guidance. Over or undercompensation can lead to disputes, regulatory scrutiny, and damage to the insurer's reputation. Correct approach analysis. The correct approach involves a comprehensive and empathetic assessment that considers the claimant's individual circumstances, the nature and severity of their injuries, and the resulting impact on their daily life and well-being. This approach aligns with the principles of fair compensation, which aim to restore the claimant, as far as money can, to the position they would have been in had the injury not occurred. It requires careful consideration of medical evidence, expert opinions on prognosis and long-term effects, and direct engagement with the claimant to understand their lived experience. Regulatory frameworks, such as those governing insurance claims handling, mandate that insurers act with due skill, care, and diligence, and that assessments are fair and reasonable. This approach prioritizes a holistic view, acknowledging the intangible but significant impact of injuries. Incorrect approach is analysis. One incorrect approach is to rely solely on predefined schedules or guidelines without considering the unique circumstances of the claimant. This fails to acknowledge the individuality of human experience and can lead to an assessment that is either too low, failing to adequately compensate for the specific impact on the claimant, or too high, exceeding what is fair and reasonable. This approach risks breaching the regulatory duty to handle claims fairly and could be seen as a failure to exercise due skill and care. Another incorrect approach is to minimize the claimant's subjective experience and focus only on easily quantifiable aspects of their life. This disregards the significant impact of non-economic loss on a claimant's overall well-being and quality of life. It fails to recognize that the purpose of compensation is not merely to replace lost earnings, but to address the broader consequences of an injury. Such an approach is ethically questionable and likely to contravene regulatory expectations for fair claims handling. A further incorrect approach is to adopt an overly adversarial stance, treating the claimant's claims of suffering and loss of amenity with suspicion, and demanding excessive proof for subjective experiences. While due diligence is necessary, an overly skeptical approach can alienate the claimant, hinder communication, and lead to an unfair assessment. This can breach the regulatory requirement for insurers to treat customers fairly and to engage constructively in the claims process. Professional reasoning. Professionals should adopt a balanced approach that combines objective evidence with a thorough understanding of the claimant's subjective experience. This involves 1. Gathering comprehensive medical and expert evidence to understand the physical and psychological impact of the injury. 2. Actively listening to and understanding the claimant's account of how the injury has affected their life, including their hobbies, social activities, and general well-being. 3. Consulting relevant legal precedents and judicial guidance on non-economic loss assessment to ensure consistency and fairness. 4. Applying professional judgment, informed by experience and regulatory requirements, to arrive at a fair and justifiable assessment. 5. Maintaining open communication with the claimant throughout the process, explaining the assessment methodology and rationale. Question 18. Compliance review shows that a commercial property policyholder has submitted a claim for significant damage to their building, which is approximately 30 years old, but has undergone some recent renovations to its electrical and plumbing systems. The policy provides for replacement cost coverage on the building structure. The insurer's initial assessment suggests that while the original structure has depreciated, the recently upgraded systems are essentially new. The claims handler is considering how to best value the loss. Which of the following approaches best aligns with the policy terms and regulatory expectations for this scenario? Option A. Negotiate a settlement based on the policyholder's perceived financial need, regardless of the specific valuation method outlined in the policy. Option B. Apply replacement cost valuation to the entire damaged building structure, including the older original components and the newer upgraded systems, to reflect the cost of restoring the property to its pre-loss condition with like kind and quality. Option C. Apply replacement cost valuation only to the recently upgraded electrical and plumbing systems and actual cash value to the older, original portions of the building structure. Option D. Apply actual cash value to the entire damaged building structure, deducting depreciation for the age of the building and its components, to reflect the current market value of the damaged property. The correct answer is B. Apply replacement cost valuation to the entire damaged building structure, including the older original components and the newer upgraded systems, to reflect the cost of restoring the property to its pre-loss condition with like kind and quality. Explanation. This scenario presents a professional challenge because the insurer must determine the appropriate valuation method for a damaged commercial property, balancing the policyholder's expectation of full restoration with the insurer's obligation to indemnify based on established valuation principles. The complexity arises from the differing outcomes of actual cash value (ACV) and replacement cost (RC) valuations, particularly when the property is older and has undergone some upgrades. The insurer's decision requires a thorough understanding of the policy wording, relevant legislation, and ethical considerations to ensure fair treatment of the policyholder, while adhering to contractual and regulatory obligations. The correct approach involves applying the replacement cost valuation method, as specified by the policy, for the damaged portions of the building. This method aims to indemnify the policyholder by providing the cost to repair or replace the damaged property with materials of like kind and quality, without deduction for depreciation. This aligns with the principle of indemnity, which seeks to restore the insured to their pre-loss financial position. The policy's explicit mention of replacement cost coverage for the building structure dictates this approach. Adhering to this method ensures compliance with the policy contract and regulatory expectations for fair claims handling, preventing underindemnification of the policyholder for covered losses. An incorrect approach would be to solely apply actual cash value (ACV) to the entire claim. ACV deducts depreciation from the replacement cost, reflecting the property's age and wear and tear. While ACV is a valid valuation method in some contexts, it would be inappropriate here if the policy clearly stipulates replacement cost coverage for the building. This would likely result in underindemnification and a breach of the policy contract, potentially leading to regulatory scrutiny and a breach of the duty of good faith and fair dealing. Another incorrect approach would be to apply replacement cost only to the newer, upgraded portions of the building and actual cash value to the older, original sections, without clear policy language or statutory allowance for such a hybrid approach. This selective application of valuation methods, without a clear contractual or legal basis, could be seen as arbitrary and unfair to the policyholder, potentially leading to disputes and regulatory noncompliance. It fails to uphold the principle of indemnity consistently across the covered loss. The professional decision-making process for similar situations should begin with a meticulous review of the insurance policy to identify the specific valuation method applicable to the damaged property. This should be followed by an assessment of the damage and the property's condition, considering any relevant policy endorsements or exclusions. Consultation with internal claims experts and, if necessary, external adjusters or legal counsel can provide further clarity. The insurer must then communicate the chosen valuation method and its implications clearly and transparently to the policyholder, explaining the basis for the decision and providing supporting documentation. Throughout the process, maintaining open communication and acting with integrity are paramount to fostering trust and ensuring a fair resolution. Question 19. Comparative studies suggest that while efficient claims settlement is a key performance indicator, a robust risk management process is paramount for long-term insurer viability. Considering the regulatory framework for UK insurance firms, which of the following approaches best exemplifies the integration of risk management principles into the claims handling process to ensure both policyholder protection and financial solvency? Option A. Implementing a comprehensive risk management framework that includes systematic identification of potential claims-related risks, assessment of their likelihood and impact, development of appropriate control measures, and ongoing monitoring of their effectiveness. Option B. Maintaining historical claims handling procedures without regular review, assuming that past practices are sufficient to manage current and future risks. Option C. Focusing solely on reducing the average cost per claim by limiting investigative resources and relying on standard settlement procedures for all claim types. Option D. Prioritizing the rapid closure of all claims, regardless of the complexity or potential for fraud, to meet internal efficiency targets and minimize operational costs. The correct answer is D. Prioritizing the rapid closure of all claims, regardless of the complexity or potential for fraud, to meet internal efficiency targets and minimize operational costs. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an insurance claims handler to balance the immediate need to settle a claim with the long-term imperative of maintaining the insurer's financial stability and adhering to regulatory solvency requirements. The pressure to resolve claims quickly, especially in a high-volume environment, can lead to overlooking potential systemic risks or inadequate control measures. A claims handler must exercise sound judgment to ensure that settlements are fair and compliant, without compromising the insurer's ability to meet future obligations. Correct approach analysis. The correct approach involves a comprehensive risk management process that begins with thorough risk identification, moving to assessment of likelihood and impact, then implementing appropriate controls, and finally establishing ongoing monitoring. This systematic methodology ensures that potential risks are proactively addressed. Specifically, for the Advanced Claims Exam (CII) in the UK, this aligns with the principles of the Financial Conduct Authority (FCA) and the Prudential Regulation Authority (PRA) regarding robust governance and risk management frameworks for insurance firms. The FCA's principles for businesses, particularly Principle 3, Customers' Interests, and Principle 7, Communications with Clients, necessitate that firms manage their business effectively and identify and manage risks. The PRA's Solvency Roman II framework further mandates that firms have robust risk management systems in place to ensure solvency and protect policyholders by identifying the potential for fraud, assessing its impact on reserves and profitability, implementing controls like enhanced due diligence for suspicious claims, and monitoring the effectiveness of these controls. The claims handler is upholding these regulatory obligations. Incorrect approach is analysis. An approach that focuses solely on expediting claims settlements without a corresponding risk assessment and control framework fails to meet regulatory expectations. This would represent a failure to manage the business effectively, FCA Principle 3, and could lead to inadequate reserving, impacting the insurer's solvency and ability to pay future claims, a direct contravention of PRA requirements under Solvency Roman II. An approach that prioritizes cost-cutting in claims handling by reducing necessary investigations or controls, even if it appears efficient in the short term, is also flawed. This overlooks the risk of fraud or overpayment, which can have significant financial implications and undermine customer trust, violating FCA Principle 3 and Principle 7. An approach that relies on historical data without adapting to emerging risks or changes in the claims environment is insufficient. The risk management process must be dynamic. Failing to identify new or evolving risks, such as those associated with new technologies or economic conditions, means that controls may become obsolete, leaving the insurer exposed. This demonstrates a lack of effective risk management and governance, contrary to regulatory expectations. Professional reasoning. Professionals should adopt a structured, risk-based approach to claims handling. This involves 1. Risk identification, proactively identifying potential risks inherent in the claims process, such as fraud, errors, regulatory breaches, and operational inefficiencies. 2. Risk assessment, evaluating the likelihood and potential impact of identified risks on the insurer's financial position, reputation, and policyholder interests. 3. Risk control, designing and implementing measures to mitigate or manage identified risks, such as enhanced verification procedures, fraud detection systems, and staff training. 4. Risk monitoring, continuously reviewing the effectiveness of control measures and the overall risk landscape, making adjustments as necessary to ensure ongoing compliance and financial stability. This systematic process ensures that claims handling is not only efficient, but also robust, compliant, and aligned with the long-term interests of both the insurer and its policyholders, as mandated by the FCA and PRA. Question 20. Process analysis reveals that a claims handler is presented with a complex claim involving a potential coverage dispute due to ambiguous policy wording. The handler has identified two plausible interpretations of the wording, one favoring the policyholder and the other favoring the insurer. The handler's immediate instinct is to proceed with the interpretation that offers the insurer the greatest protection from financial loss, without further investigation into the policyholder's specific circumstances or the broader context of the policy, which approach best aligns with the legal and regulatory environment for claims handling. Option A. Conduct a thorough investigation of the claim, objectively assess all relevant policy terms and conditions, and communicate a clear, reasoned decision to the policyholder, explaining the basis for the interpretation adopted. Option B. Rely on internal company precedent for similar ambiguous wording, even if the current claim's circumstances differ significantly, to ensure consistency in claim settlements. Option C. Delay the decision-making process until further clarification on the ambiguous wording can be obtained from legal counsel, without informing the policyholder of the reason for the delay. Option D. Immediately apply the interpretation of the policy wording that results in the lowest payout for the insurer, citing the ambiguity as justification for this conservative approach. The correct answer is A. Conduct a thorough investigation of the claim, objectively assess all relevant policy terms and conditions, and communicate a clear, reasoned decision to the policyholder, explaining the basis for the interpretation adopted. Explanation. Scenario analysis. This scenario is professionally challenging because it requires the claims handler to balance the insurer's need to manage its financial exposure with the policyholder's right to a fair and timely claims settlement. The complexity arises from interpreting ambiguous policy wording and applying it to a specific factual scenario, all within the strict confines of the regulatory framework governing claims handling. Failure to adhere to these regulations can lead to regulatory sanctions, reputational damage, and financial penalties, in addition to potential legal action from the policyholder. Correct approach analysis. The correct approach involves a thorough and objective investigation of the claim, a diligent review of the policy terms and conditions, and a clear, well-reasoned decision communicated transparently to the policyholder. This aligns with the principles of fair dealing and good faith mandated by regulatory bodies. Specifically, it requires the claims handler to act with reasonable speed and diligence, to investigate all relevant circumstances, and to provide a clear explanation for any decision made, particularly if the claim is declined or only partially paid. This approach ensures compliance with the spirit and letter of the law, fostering trust and upholding the insurer's obligations. Incorrect approach is analysis, an approach that immediately seeks to limit the payout based on a narrow interpretation of a single clause, without fully investigating the circumstances or considering other relevant policy provisions, fails to meet the duty of good faith and fair dealing. This can be seen as an attempt to avoid liability rather than to fairly assess the claim. An approach that delays the investigation and decision-making process without valid justification, or fails to keep the policyholder informed of the progress, breaches the regulatory requirement for prompt and efficient claims handling. Such delays can prejudice the policyholder and may be interpreted as unfair treatment. An approach that relies on internal guidelines or assumptions about policyholder behavior rather than a factual investigation and objective application of policy terms demonstrates a lack of due diligence and a failure to properly assess the claim's merits. This can lead to an incorrect decision that is not supported by the policy or the facts. Professional reasoning. Professionals should adopt a systematic approach to claims handling. This involves 1. Understanding the policy obligations and the regulatory environment. 2. Conducting a comprehensive and objective investigation of the facts. 3. Applying the policy terms and conditions fairly and consistently to the established facts. 4. Communicating clearly and promptly with the policyholder, explaining decisions and next steps. 5. Documenting all actions and decisions thoroughly. This structured process ensures that claims are handled ethically, legally, and efficiently, protecting both the policyholder and the insurer.